If a person has been convicted in a criminal case, does he or she have the right to travel abroad? And what if the criminal case is connected to raising funds for a terrorist activity? Hello and welcome to ThePrint. This is Khadija Khan from New Delhi, and today we're going to answer the question of whether convicts can travel abroad and if they have the right to seek renewal of their passports. Recently, the Supreme Court has made it clear that the law does not disentitle a person facing criminal proceedings from getting a passport while allowing a convict who was facing charges under the Unlawful Activities Prevention Act or the UAPA in relation to a coal mining scam to renew his passport. The ruling came in a 2018 case against a man who was accused of extortion, levy collection, and related activities in the coal mining areas of Amrapali and Magad, including the alleged funding of a proscribed organization. A two-judge bench of Justices Vikram Nath and A.G. Massey ruled that the freedom of a citizen to move, to travel, to pursue livelihood and opportunity subject to law is an essential part of the guarantee under Article 21 of the Constitution of India, emphasizing that the government may, where a statute so provides, regulate or restrain that freedom in the interests of justice, security, or public order. The court added that such restraint must be narrowly confined to what is necessary, proportionate to the object sought to be achieved, and clearly anchored in the law. Recalling the landmark rulings of the Supreme Court in the 1978 case of Menaka Gandhi or even the 2004 case of Naveen Jindal, where the court had upheld the right to travel abroad and the right to a passport as facets of the right to personal liberty under Article 21, the court pointed out that this right can only be restricted if the restriction imposed on it is fair, just, and reasonable and bears a rational nexus with a legitimate purpose. Although before Kumar's passport had expired, the NIA court at Ranchi had allowed the release of his passport, but it was only for renewal purposes. In doing so, the court also directed him to deposit the renewed passport with the court and asked him to not travel abroad without permission. In May 2022, the Delhi High Court suspended his sentence in the coal block case while having no objections to him renewing his passport for 10 years. However, it said that this was on the condition that he doesn't leave the country without seeking permission. Although the Delhi High Court and the NIA Court had allowed him to renew his passport, the Regional Passport Office, Kolkata, refused to renew the same, while relying on Section 6, Clause 2F of the Passports Act, which allows passport authorities to refuse a passport or a travel document if criminal proceedings are pending against an applicant in any criminal court in India, in a case where they are sentenced to at least 2 years imprisonment. Aggrieved by this, Agarwal approached the Calcutta High Court, which also dismissed his plea for renewal of passport, which had expired in August 2023. Consequently, Agarwal moved the Supreme Court. Can convicts travel abroad? After analyzing provisions of the Passports Act, the court noted that Section 22 confers on the centre the power to exempt any person or class of persons from the operation of the specified provisions of the Act or even the rules, subject to conditions like if it deems it necessary to do so in public interest. Deriving validity from this provision, the central government issued a notification in 2019 which created an exemption from the bar under Section 62F in favor of persons facing criminal proceedings who obtained permission from the concerned court and complied with the conditions set out in that notification. This notification, according to the court, recognized that persons facing criminal proceedings are not to be treated as absolutely disentitled to a passport. Instead, it permits such persons to obtain a passport, the court said, while adding that this is done once the concerned criminal court has applied its mind and passed an order on the issuance or use of the passport, and the applicant has given an undertaking to appear before the court when required. The notification also ties up the exemption to the conditions imposed by the courts, the bench said, while adding that, for instance, if the court specifies a period for which the passport is to be issued, the passport authority must honor that period. Where the court does not stipulate any period, the notification provides default rules, including issuance for a shorter period, ordinarily 1 year in appropriate cases, making it clear that this government notification does not in any way insist that criminal courts must in every case grant a prior blanket permission to depart from India for specified dates. The court said that providing a no objection certificate or permission from the criminal court along with the applicant's undertaking can be enough for renewal of passport in such cases. Such a procedure can even override an adverse police report with reasons recorded by the passport officer, and can also tackle situations where more than one court is dealing with the matter, and indicates that orders of all such courts are to be read together. The Passports Act does not require the criminal court to convert every permission into a one-time license to undertake a particular journey, the bench said, while adding that it equally permits the court to renew passports while retaining complete control over each instance of foreign travel by insisting on its prior leave, as both the courts had done in the present case. And that brings us to an end of today's segment. For more legal updates, keep watching The Print.